Picture a line drawn in the sand. You step across it, and suddenly you are in a completely new country playing by an entirely different rule book.
Right. The physical territory dictates the legal reality.
Exactly. And that is, it's a concept that has anchored human society for centuries. Like, you know exactly when you leave one jurisdiction and enter another. But today, simply bringing your laptop to a cafe and connecting to Wi-Fi it entirely erases that line.
Yeah, it really does.
We're living in a world where your employment rights might actually be completely detached from where you are physically sitting right now.
I mean, the ground beneath our feet hasn't moved, but the legal foundation entirely shifts the moment we log on. Physical borders have essentially been replaced by digital ones, and the implications for the average remote worker are just staggering. The old maps just do not apply anymore.
Welcome to today's deep dive. We are exploring the fascinating and honestly pretty unexpected ways your workplace rights are defined in the age of remote work.
It's a wild topic, really.
It totally is. And we are pulling our information from a massive stack of case files provided by the Australian Workplace Discrimination Representatives, or AWDR.
Right. They're a firm of non-lawyer workplace relations specialists, and they've got over 30 years of experience doing this.
Yeah. Having helped more than 16,000 clients, their files provide this incredible window into the evolution of workplace conflict. And lately, those files are highlighting a really wild new trend.
Oh, absolutely.
We are going to look at how the simple act of hitting send on an email can completely dictate your legal protections, no matter where you live on the globe. Okay, let's unpack this.
Let's do it.
Before we get into the wild global stuff, we need to set a baseline. When you look through AWDR's historical cases, the bulk of everyday workplace conflict revolves around things like unfair dismissal, toxic environments, and general protection disputes.
Right, and a massive cornerstone of those everyday disputes in Australia is the concept of procedural fairness under the Fair Work Act.
Procedural fairness.
Exactly. Procedural fairness is the absolute bedrock of the employment safety net. It essentially means a company cannot act capriciously. If they want to fire someone for, say, poor performance, there needs to be a clear, documented process.
Which means warnings, right? Like giving someone a chance to actually fix the problem.
Proper warnings, yeah. A formal opportunity to improve, and a chance for the employee to respond to the allegations before the axe falls. I mean, even if an employer has a theoretically valid reason to fire someone, say they are genuinely underperforming,
Right.
if the company skips those steps, the dismissal can still be deemed unfair. The legal process matters just as much as the business justification.
That makes total sense when the boss and the employee are in the same building. The boss calls you into their office, closes the door, and, hands you a formal written warning.
That's a traditional way.
Exactly. But the modern complication AWDR's files reveal is what happens when that procedural fairness is supposed to apply to someone who isn't even in the country. Let's look at the first case from their records. Set the scene for us.
Sure. So let's look at the 2026 case of David Sanderson versus Brightest Australia Pty Ltd. This case perfectly illustrates the digital border. David Sanderson lived and worked entirely in New Zealand.
Okay, entirely in New Zealand.
Yeah. He was hired in September 2024 to sell app subscriptions, a product called FlexiPlan for Brightest Australia, which is a company headquartered in Melbourne.
Selling app subscriptions remotely sounds pretty standard, honestly.
It does, but the expectations were incredibly high. His contract stipulated a target of 75 sales over a 15-month period.
Wow, okay.
And he only achieved 32.
Ouch.
Yeah, Sanderson felt the marketing leads he was being given were completely inadequate. He famously pushed back against his managers in an email, telling his boss, quote, "We can't produce wine from water."
Oh, I love that.
Yeah.
I mean, it's just a fantastic, slightly dramatic line to drop in a corporate performance review.
It really is.
It paints such a clear picture of remote work frustration. You are sitting at a desk hundreds of miles away, feeling totally disconnected from the resources the company is supposed to provide.
Right. It highlights a very common friction point in remote work. But the friction here was compounded by a poorly drafted employment contract. Sanderson's contract had 2 contradictory clauses regarding underperformance.
Okay. Contradictory how?
Well, Clause 13 outlined a very traditional step-by-step disciplinary process. It explicitly required a verbal warning for a first offense, followed by a formal written warning for a second, before any termination could occur.
So a textbook example of procedural fairness built right into the agreement.
Exactly. But then there was Clause 24. This clause essentially stated that if he failed to meet his monthly sales targets, the company could bypass that rigorous warning process and simply fire him with 1 week's written notice.
Oh, wow.
Yeah, it was a parallel pathway designed for a quick exit.
Companies love having those ripcords built into contracts.
Yeah.
So, how did they actually handle his poor performance? Did he use the long process or the ripcord?
Well, in July 2025, his boss sent him 2 emails with the subject line, "Performance Warning." These emails pointed out that he had only signed one flexi plan in each of the previous 2 months.
Okay, so that sounds like a warning.
You'd think so, but those emails never actually mentioned that his employment was at risk. They completely omitted any language stating he could be fired if things didn't improve.
Oh, that's a big omission.
Huge. So months passed, and then on December 8th, 2025, Sanderson was summarily fired via a text message,
A text message. Just a text message. That is brutal.
followed by an email confirming the termination, yeah. Brightest Australia cited his inability to meet the expectations of his role, paid his 1 week in lieu of notice under Clause 24, and basically considered the matter closed.
Yeah.
He was never called to a meeting, he was given zero opportunity to respond to the sudden prospect of dismissal, and he was not taken through any step of the Clause 13 disciplinary procedure.
Wait, I have to stop you right there. I have a major issue with how this even gets to court. Wait, if he lives and works entirely in New Zealand, how can he claim Australian unfair dismissal? It's like trying to use a local library card in another country. The physical jurisdiction shouldn't allow it.
Exactly. What's fascinating here is the legal magic happening entirely behind the scenes. It all comes down to legislation you wouldn't typically associate with employment rights, which is the Electronic Transactions Act.
Okay, tell me more.
In this specific scenario, we are looking at the 1999 Commonwealth version and the Victorian state version from 2000. Under these digital frameworks, a contract is legally formed where the acceptance is received.
Okay, so Sanderson is sitting in his home office in New Zealand. He reads the initial job offer on his laptop, signs the contract digitally, and hits send on his email client.
Right, and that email data travels across the Tasman Sea and arrives at a server located in Victoria, Australia. Because the actual receipt of his acceptance happened on that physical server in Victoria, the Fair Work Commission ruled that the contract was legally formed in Victoria. Sanderson met the definition of an Australian-based employee under Section 35(2) of the Fair Work Act.
That is wild. His physical body is in New Zealand, breathing New Zealand air, but his legal avatar, so to speak, is basically standing in a server room in Melbourne.
Exactly. Now, the employer recognized this danger and tried to use a specific legal loophole. There is an exclusion in the Fair Work Act for foreign employees.
Okay.
For an Australian company to dodge these Fair Work rules, a 2-part test must be satisfied. 1, the employee has to be hired entirely outside of Australia, and 2, they must perform all their duties outside of Australia.
Well, he performed all his duties in New Zealand, so that covers the second part of the test, right?
He did, but because his email acceptance landed on a server in Victoria, the law considered him legally hired inside Australia. So he failed the first part of the test, closing the loophole. He retained his status as an Australian-based employee with full protections.
That is just crazy. I mean, if you were listening to this on your laptop right now while working for a company in another state or country, really let that sink in. The moment you hit send on your employment agreement, your contract, your legal safety net might actually live wherever your employer's server farm happens to be sitting.
Yeah, your rights are traveling through fiber optic cables.
Incredible. So once Sanderson established he had the right to fight this in Australia, how did the commission actually view that text message firing?
Well, they looked at the Small Business Fair Dismissal Code. They found that while low sales figures were indeed a valid reason for dismissal, the execution was incredibly harsh and procedurally deficient.
Right, because of the text message.
And those 2 performance warning emails from July, they were deemed to be mere exhortations to improve. They were basically just a manager saying do better, rather than a formal warning that his livelihood was on the line.
Yeah, and firing someone by text just completely removes any chance for a dialogue.
The commission agreed. Furthermore, they actually supported Sanderson's wine from water defense.
Oh, they did?
They did. They noted the significant cause of the sales shortfall was the low quality of marketing leads provided by the company, not his personal work ethic. They concluded there was probably not much more he could have done, so he was awarded 2 weeks gross pay, which is an acknowledgement that the process was completely botched.
Well, good for him. So Sanderson proved this invisible digital tether works across the Tasman Sea. But New Zealand is basically next door to Australia. Here's where it gets really interesting.
Oh, it goes much further.
Right. What happens if we stretch this invisible tether across the globe? Like, does the server logic still hold up for a multinational executive operating on a completely different continent?
It does, and it scales up massively. Let's look at the 2023 case of Gautam Paramu versus Lake Resources NL. This involves the C-suite level.
Okay. Moving up from app sales.
Yes. Gautam Paramu was a United States citizen. He was approached by a recruiter based in Chile. His job interviews were conducted entirely via video conferencing, speaking with company representatives who were sitting in Sydney and Perth.
Got it. So he was being hired as the chief operating officer for a mining company headquartered in Sydney, specifically to run their Kachi lithium brine project located over in Argentina.
Correct.
So we have a U.S. citizen recruited in Chile working in Argentina for an Australian company. And just to be absolutely clear on the geography here, he performed all his duties in South America and never, not once, traveled to Australia.
He never set foot in the country. Yet, when he was dismissed effective immediately on January 9th, 2023, he immediately lodged a Fair Work General Protections claim in Australia.
Naturally, the employer, Lake Resources, tried to block this claim immediately with a jurisdictional objection.
Oh, of course.
They pointed to that exact same loophole we just discussed, arguing Paramu was engaged outside Australia to perform duties outside Australia. To the company, engaged or hired meant his physical location when he signed the contract in South America. The work was in South America. Case closed.
That was their argument, yes, under Section 35(3).
Well, wait, isn't the employer right here? If I'm physically sitting in my living room in South America when I hit send on an email, isn't that where the action happens? It's like dropping a letter in a mailbox. The mailing happens where I am standing. The action is completed on my end.
If we connect this to the bigger picture, we see why that specific mailbox analogy is so crucial to legal history and why it completely fails in modern digital contract law.
Really? How so?
Well, the postal rule you were referencing actually used to be the absolute legal standard. For centuries, a contract was considered formed the moment an acceptance letter was dropped in the post box.
Right, because in the 1800s, it might take weeks for a ship or a train to deliver that letter. The sender needed some kind of legal certainty that their acceptance was valid the moment they mailed it, even if the letter's delayed in transit.
Exactly. The postal rule was a necessary adaptation to the delays of physical transportation.
Yeah.
But electronic communications require a fundamentally different framework because the delay is gone. An email isn't a physical document sitting in a mailbag.
It's just data.
It is data moving almost instantaneously. Paramu's legal team understood this shift. They argue that employment contracts are formed specifically where the communication is accepted and received, citing previous digital era cases like Winter v. GHD Services and ACCC v. Valve.
Wait, hold on. In the Sanderson case with the Kiwi salesman, you said the contract was formed where the physical server was located in Victoria. Now you're saying it's about the company's place of business in Sydney, New South Wales. Why did the rules change between the two cases?
That is a brilliant catch, and it highlights the hidden complexity of digital law. It comes down to how different states updated their versions of the Electronic Transactions Act. In the Sanderson case, they were dealing with the Victorian state law, which heavily anchored receipt to the physical location of the server infrastructure.
Okay, but Paramu.
The Paramu case fell under the New South Wales version of the Act from 2000.
So New South Wales handles the destination of an email differently than Victoria.
They do. New South Wales recognized that in an era of cloud computing, a company might not even know where its servers are physically located. I mean, they could be bouncing between data centers dynamically all over the globe.
That makes sense.
So the New South Wales law stipulates that an electronic communication is legally received at the addressee's designated place of business, regardless of where the server rack is actually sitting.
Okay, let me trace the sequence for Paramu then. Lake Resources technical director emailed him a final copy of the executive services agreement. That initial email is the contractual offer. Paramu signed the agreement the next day in South America and emailed it back. That is his acceptance.
Right, and the director countersigned it and sent a copy back for his files. Because Paramu's signed acceptance landed in an inbox belonging to a company headquartered in Sydney, under the New South Wales Electronic Transactions Act, he was legally hired in Sydney.
The moment that email hit their corporate inbox, the legal connection was forged in New South Wales. His status as an American citizen, the recruiter in Chile, the lithium mine in Argentina, none of that superseded the digital path of that PDF.
Nope, none of it. The Fair Work Commission dismissed the employer's jurisdictional objection entirely. The contract was formed in Sydney, making Paramu an Australian-based employee, and his claim was allowed to proceed.
Wow.
The entire defense of a multinational mining company regarding their own chief operating officer completely crumbled because of how an email inbox designates a place of business.
It just completely redefines what it means to go to work. I mean, stepping back from all these legal mechanics, AWDR's materials make one thing abundantly clear. Whether you are fighting a toxic workplace, dealing with systemic bullying, or facing a sudden unfair firing via text message, the absolute full step is knowing your rights.
You have to.
You have to know what protections you actually possess before you can even begin to seek justice. And AWDR's files show that for modern workers, those rules are rarely as simple as they appear on the surface.
The modern workplace is no longer defined by the four walls of an office. As these two cases vividly demonstrate, your rights might not be determined by the laws of the country where you pay rent, where you buy your groceries, or where you physically sit down to type.
So what does this all mean for you? If you are one of the millions of people working remotely right now, logging into virtual meetings from your kitchen table, your entire employment safety net is floating in the digital ether.
It really is.
How you can be fired, the warnings you absolutely must receive, the protections against discrimination, all of it might be governed entirely by the laws of a city you have never even visited. Your legal shield is fundamentally tied to the destination of your data.
This raises an important question, though. We have essentially anchored employee rights to the digital infrastructure, to the location of a server in Victoria or a designated inbox in Sydney. We have established this new, invisible digital border that replaces the old physical line in the sand.
Right. And since the exact geographical location of a received email or the location of a company's cloud-based inbox dictates the legal jurisdiction of an employment contract, it opens up a massive loophole for corporations.
A huge one.
What happens if a global company deliberately hosts its email servers in international waters? Or what if they legally designate their digital place of business in a completely unregulated country with absolutely zero worker protections? In a fully cloud-based future where the concept of a headquarters is just distributed data across nodes worldwide, could your workplace rights just vanish into thin air?